In this lecture, we shall discuss the 7th set of revision questions and answers. And this set of questions will also be on pleadings, and it will be a continuation of the last set of questions we discussed. Remember, these are revision questions and are only to be tackled after you have read the substantive law and appreciated the different aspects. The first question we shall begin with will be question 31, because in the previous lecture we ended as question 30. And the first question reads as follows. When a defendant in the statement of defense fails to deny any material facts contained in the plaintiff's statement of claim, same shall constitute an admission, an implied admission of such a material fact. This is the essence of Order 11 Rule 13 of the CI 47. And the question is, are there any exceptions to this rule? Again, the question is that when a defendant in the statement of defense fails to deny any material facts contained in the plaintiff's statement of claim, same shall constitute an implied admission of such a material fact. And the question is that, are there any exceptions to this rule? And this rule is the rule under Order 11 Rule 13 that says that when a defendant in the statement of defense fails to deny any material facts contained in the plaintiff's statement of claim, same shall constitute an implied admission of such a material fact. This is the essence of Order 11 Rule 13 of the CI 47. Are there any exceptions to this rule? The answer is as follows. Yes, there are exceptions. Number one exception is that when a plaintiff alleges that he has suffered damage, any allegation as to the extent of damage or the amount of damages shall be deemed to be traversed unless specifically admitted. This has been provided for under Order 11 Rule 13, Sub-Rule 4 of the CI 47. One exception is that when the plaintiff alleges that he has suffered damage, any allegation as to the extent of damage or the amount of damages shall be deemed to be traversed unless specifically admitted. This has been provided for under Order 11 Rule 13, Sub-Rule 4 of the CI 47. Another exception is under Order 5 Rule 7, which provides that a person with disability shall not be taken to admitting the truth of any allegation made in the pleading of the opposite party by reason only that the person with disability has not traversed it in his or her own pleadings. So let me explain the question and explain the answer. Generally, as a defendant in your statement of defense, you are supposed to deny what you don't want to admit. But if you fail to deny, it shall be construed to be an implied admission. Are there any exceptions to this rule? We are told that first exception is that if you are the plaintiff and you are alleging that you have suffered damage, any allegation as to the extent of damage, automatically the law is that the defendant is deemed to have denied it unless he has specifically admitted. So if he didn't expressly admit it, you can't say he has impliedly admitted because he failed to deny it. That's one. And the other one is when you are dealing with a person with disability, under Order 5. The rule is that a person with disability shall not be taken to admitting the truth of any allegation made in the pleading of the opposite party by reason only that the person with disability has not traversed it in his or her own pleadings. The next question reads as follows. When a defendant in a statement of defense fails to deny any material facts contained in the plaintiff's statement of claim, same shall constitute an implied admission of the material facts. In the same vein, when the plaintiff fails to file a reply to a statement of defense, shall such a failure to file a reply constitute an admission of the material depositions contained in the statement of defense? In the same vein, when the plaintiff fails to file a reply to a statement of defense, shall such a failure to file a reply constitute an admission on the material averment contained in the statement of defense? The answer is as follows. The answer is no. This is because when a plaintiff fails to file a reply, the law is that there shall be a joinder of issue on that defense. The joinder of issue operates as a denial of every allegation of facts made in the pleading. This has been provided for under Order 11 Rule 14 of the CI 47. The next question reads as follows. What is the purpose of a reply, and at what stage of the proceedings is it filed in civil proceedings in the High Court of Ghana? What is the purpose of a reply, and at what stage of proceedings is it filed in the High Court of Ghana? This is an answer that we've already dealt with in the previous set of questions, but we shall still look at the answer. The answer is as follows. There's no need to file a reply if the only purpose of and the goal of the plaintiff is to deny the allegations contained in the statement of defense. This is because pursuant to Order 11 Rule 14 Sub Rule 1 of the CI 47, if there's no reply to a defense, there shall be a joinder on that joinder of issue on that defense. So there's no need to file a reply if the only purpose of and goal of the plaintiff is to deny the allegations contained in the statement of defense. This is because pursuant to Order 11 Rule 14 Sub Rule 1 of CI 47, if there's no reply to a defense, there shall be a joinder of issue on that defense, which means that all the material allegations of fact in the defense have been denied. However, if there is a need for the plaintiff to set up an affirmative case of his own, which will serve the purpose of answering facts alleged by the defendant in his statement of defense, then the plaintiff might have to file a reply. For this reason, a reply may be necessary for compliance with Order 11 Rule 8, which provides that a party shall, in any pleading subsequent to a statement of claim, plead specifically any matter, for example, performance, release, any limitation provision, fraud, or any fact showing illegality, which the party alleges makes any claim or defense of the opposite party not maintainable, or which, if not specifically pleaded, might take the opposite party by surprise, or which raises issues of facts not arising out of the preceding pleading. Also, we proceed to say that the plaintiff may in his reply admit part of the defense. The plaintiff may also traverse. The plaintiff may also confess and avoid allegations in the defense, as has been noted in the case of Hall versus Eve. The reply is the proper place for meeting the defense of confession and avoidance. The plaintiff must in his reply not set up a new cause of action, which is not raised in either the writ or statement of claim, since that would be contrary to Order 11 Rule 10, which has the rule against departure. Next question. What are the basic or principal rules of pleadings? What are the basic or principal rules of pleadings? The answer is as follows. Pleadings must contain only material facts and not law. This means pleadings must contain in summary form all the material facts that a party seeks to rely upon to prove his or her claim or to defend the claim. A party is not permitted to discuss particular laws in the pleading. Even though a party may raise a point of law as to jurisdiction, capacity, or limitation, as provided for under Order 11, Rule 11, Sub Rule 1. Again, the party is not permitted to discuss particular laws in the pleading, even though a party may raise a point of law as to jurisdiction, capacity, or limitation, as provided for under Order 11, Rule 11, Sub Rule 1 of the CI 47. Number 3, pleadings must not contain evidence. Therefore, a party cannot annex a receipt or agreement to his writ of summons. Evidence is rather adduced during the trial. Pleadings must not contain evidence. Point 4, under Order 11, Rule 8 of CI 47, a party shall, in any pleading subsequent to a statement of claim, specifically plead any matter which the party alleges makes any claim or defense of the opponent not maintainable, or which, if not specifically pleaded, might take the opponent by surprise. Examples of such matters to be specifically pleaded include performance, release, any limitation provision, fraud, or any fact showing illegality. Point 5. Under Order 11, Rule 12, a party is required to give particulars of any of the following: misrepresentation, fraud, breach of trust, willful default, or undue influence on which the party pleading relies. So these are the basic or principal rules of pleadings. Remember them. We plead facts and not law, number 1. Number 2, even though a party is not permitted to plead law, the party can raise a point of law. Number 3, we plead facts and we don't plead evidence. Number 4 and number 5, we've dealt with them as well. Number 5 dealt with providing particulars. If you are dealing with misrepresentation, fraud, breach of trust, willful default, or undue influence, or other matters like defamation, negligence, you are required to also provide particulars. The next question reads as follows: what is the distinction between set-off and counterclaim? What is the distinction between a set-off and a counterclaim? The answer is as follows. A counterclaim is a cross-action which has an existence independent on its own, whereas a set-off remains a defense. Therefore, when the plaintiff withdraws his action or the action is struck out, because the counterclaim has an independent existence, the defendant can proceed with a counterclaim against the plaintiff. However, when the defendant relies on a set-off, which is merely a defense, when the plaintiff's action is struck out or discontinued, the set-off also collapses. Second difference is that set-off is used as a defense to reduce or extinguish the liability of the defendant to the plaintiff. In monetary claims against the defendant, however, a counterclaim can be in respect of any cause of action which is not related to a monetary claim. So, for example, as for counterclaim, if you've sued me and it's about defamation, and I think I can counterclaim breach of contract, I can counterclaim declaration of title to land, I can counterclaim it. It is when I counterclaim and the court thinks that they can't try the two cases together, that's when the court will order separate trials. But set-off must only be related to a monetary claim. A counterclaim can be in respect of any matter. Next difference is that a set-off must only be against the plaintiff, who is a party to the action. Of course, if you are claiming set-off, it is the person who has sued you that you'll be using a set-off against. But a counterclaim can be made against the plaintiff and other persons who are not even parties to the suit. So set-off must only be against the plaintiff who is a party to the action. However, a counterclaim can be made against the plaintiff and any other persons who are not even parties to the suit. Next question reads, how would you raise customary law in pleadings? How can a party raise customary law in pleadings? The answer is as follows. Under Order 11 Rule 11 of the CI 47, a party is required to state the customary law rule with particulars to show the nature and effect of the customary law rule in question, as well as the geographical area and ethnic group to which it relates. Again, under the 11 Rule 11, a party is allowed to plead a rule of customary law. Such a party is required to state the customary law rule with particulars to show the nature and effect of the customary law rule in question, as well as the geographical area and ethnic group to which it relates. The next question reads as follows. And this is a very critical question. In cases where specificity is mandated for the denial of pleaded factual allegations in a statement of claim, what purpose does a general traverse serve? In a statement of defense, can a general traverse alone effectively rebut the plaintiff's claim? The question seeks to interrogate the effects of a general traverse, because you remember we have previously mentioned that when a party fails to specifically deny a material allegation of fact, that party will be deemed to have impliedly admitted. So let's say, for example, that the plaintiff has made some averment in the statement of claim, and the defendant fails to specifically deny those averments. But then there's the general traverse in paragraph 1. The general traverse reads, save as herein after expressly admitted, the defendant denies every material allegation of fact contained in the plaintiff's statement of claim. Or you can have another general traverse, except where expressly admitted, the defendant denies every allegation of fact contained in the plaintiff's statement of claim, as if same have been set out in extenso and denied in seriatim. In other words, the defendant is saying that apart from what they expressly admit, they deny every allegation of fact in the statement of claim. So assuming the defendant has the general traverse there, and for example, under paragraph, the defendant fails to specifically deny paragraph 5 of the statement of claim, would that general traverse kick in to say that because the defendant has already said at paragraph 1 that he's denied every material allegation of fact, then it means that he's also denying paragraph 5? In other words, what is the effect of a general traverse? Does it effectively rebut a plaintiff's claim, especially when the defendant has not specifically denied that particular allegation? Take your time and listen to this answer and pay attention to the details. The answer is as follows. A general traverse is a denial of all averments in the pleading, without specially dealing with or denying each averment in the statement of claim. The CI 47 appears to frown on such a means of denial. This is because under Order 11 Rule 13 Sub Rule 1, any allegation of fact made by a party in the party's pleading shall be deemed to be admitted by the opposite party unless it is traversed by that party in a pleading or a joinder of issue, and that Rule 14 operates as a denial of it. Further to this, Order 11 Rule 13 sub Rule 3 provides that any allegation of fact made in the statement of claim or counterclaim which the party on whom it is said does not intend to admit shall be specifically traversed by the party in the party's defense or defense to counterclaim. And the general statement of non-admission shall not be a sufficient traverse of them. What this is saying is that any allegation of facts contained in the statement of claim which is said on the defendant must be specifically denied in the party's defense, and the general statement of non-admission shall not be deemed to be a sufficient traverse. And as a matter of fact, in the case of Evelyn Esiedu Ofe versus Yao Asamoah, it was held that a pleading to the effect that one could not admit or deny does not amount to a denial. It was further affirmed by the court that a party who intends to deny an averment in a pleading must do so specifically. It was further affirmed by the court that a party who intends to deny an averment in a pleading must do so specifically. So at this point, you are saying that the judicial posture is to say that if you want to deny it specifically. Next point. Although general traverse is not enough to deny an allegation, in practice, it assists lawyers in bridging gaps that may be in the statement of defense. It's very good because at least when you put it over there, you have some comfort in your mind that if you forget to specifically deny one particular paragraph in the statement of claim, you know you are relying on the general traverse to cover you. When it is couched in this proper form, it puts the matter at large and puts the opponent to prove those allegations. In other words, if you couch it very well, then it means that you have already denied everything already in the statement of claim. So they are the plaintiff, and they must bring evidence to prove those facts because you are deemed to have denied them. This has been affirmed in the case of Ansah versus Buzanga, as well as Ache, AKYER, versus Ghana Industrial Corporation. And finally, generally, even though a general traverse may suffice as a denial of averment contained in a statement of claim, it is in the best interest of the defendant to specifically deny any material averments contained in the statement of claim and further aver facts in support of the defense to that claim. Next question reads, what is meant by the rule against departure in pleadings? What is meant by the rule against departure in pleadings? And the answer is as follows. According to Order 11 Rule 10 of the CI 47, a party will not be allowed in a subsequent pleading to make any allegation of fact which is inconsistent with the previous pleading. In Hammond and Odwe, the plaintiff was by his reply setting up a case which was completely inconsistent with his former pleading, without asking for leave to amend the statement of claim. The court held that the trial judge should have disregarded that part of the reply, which was at variance with the case put forward in the statement of claim. According to Order 11 Rule 10 of the CI 47, a party will not be allowed in the subsequent pleading to make any allegation of facts which is inconsistent with the previous pleading. In Hammond and Odwe, the plaintiff was by his reply setting up a case which was completely inconsistent with his former pleading, without asking for leave to amend the statement of claim. The court held that the trial judge should have disregarded that part of the reply, which was at variance with the case put forward in the statement of claim. And then, for our next question, what is a counterclaim and how is it different from a set-off? Also, we've answered this question too already. in this same set of questions. So we shall move on to the next question. On what basis may a court strike out pleadings, and at what stage of the proceedings can that be done? We've done this already, but we shall look at the answer. The grounds on which the court will strike out any pleading are as follows. When the pleading does not disclose any reasonable cause of action or defense, or the pleading is scandalous, frivolous, or vexatious, or the pleading may prejudice, embarrass, or delay the fair trial of the action, or the pleading is otherwise an abuse of the process of courts. And when the court strikes out the pleading, the court may order that the action be stayed or dismissed, or judgment may be entered accordingly for the party. And take note that the application to strike out pleadings may be made at any stage of the proceedings. This is the end of the 7th set of questions for civil procedure, and this set of questions also related to pleadings. Thank you.